Here we have the man that I know a lot of you have come here specifically to see. This is Maximilian Schrems, who is an Austrian lawyer, activist, and all-round pain in the ass for a lot of people. And he is going to tell you all about his case and why we should care.
Introduction. Okay, thanks for coming back. I was told to talk a little bit about the Privacy Shield litigation we did, or the Safe Harbor, as it used to be called. So a couple of intro stuff. I think what's interesting in privacy debates to kind of put up front is that I think privacy is a highly cultural issue. So even within the European Union, we often talk about privacy, and if you ask everybody in the room, everybody has a different opinion. And we have this grayscale debate, so it's always a matter of balancing interests. And that all leads to a situation where there's no right or wrong, and that's oftentimes really interesting compared to other debates where you can kind of logically think about stuff. Oftentimes privacy is really a matter of where your position is. However, at the same time, we have like global networks. There's a US dominance in these global networks, and we have these EU fundamental rights, and I think all of this kind of gives a really interesting background to talk about all of that. A couple of general issues, just to give you an intro of what I did. I was actually studying in the Silicon Valley for half a year. For a while, I did privacy stuff before. It was interesting because there were a lot of US companies there and talking about European privacy. They didn't know that the European is in the room, so that made it a little bit more honest. And the basic message was you can do whatever you want to do in Europe. Nothing is going to happen anyways. And that's exactly the problem we have, I think, in privacy law right now in Europe is it's not really a lot of consequences if you don't follow the law. I actually then got the data from Facebook. It was back then 1,200 pages. That's basically the paper stack if you print it out. I got it in PDF file, so we're environmentally friendly. And it was interesting because about 300 pages of it, for example, was the deleted data. So you see right here, it says deleted true, and that's a message, and the deleted data came right along. So that was kind of the background. That whole story became really popular in the media, especially in Central Europe, so we were like all over the place. A couple of things that we looked into back then was, as I said, just the deleted data. So that's my original Facebook data. Blacked out, obviously, for privacy reasons. But this is, for example, a message that I deleted, and that's the deleted message then coming up right in your data set. So it's only flagged as deleted, not really taken away from the servers. And we had a lot of these things. They actually ask you if you really want to delete this message. There's whole data categories, like all the friends you've deleted. It was interesting because you could actually see that other people deleted you, and I was like, she deleted me. And you got like deleted email addresses that I've never used. There's like friend requests of people. What was interesting, for example, poke. So if someone pokes you on Facebook, it was kept forever, even you'd want to delete it. There were whole data categories, like, for example, last location. I never used any GPS tracking thing. I never checked into any place with Facebook. But they still figured out from my IP address, very likely, that the last location I've been at was at the university campus in California, where I was. So there's a lot of like data that happens to be generated in the background. We also looked into kind of what they call big data now. That's my friends lists and the friends lists of friends kind of connected. And from that, you can kind of see a lot of your personal relationships. That's like my university, schools, friend groups. I was, for example, instead of going to the military in Austria, I went to the Red Cross and was driving an ambulance basically for a year, and that's all the friends from there, and they all put that into their profile. I never put it online, but you can still kind of calculate these things. And if you use stuff like that, you can really go into this whole big data thing quite well, as Wolfie described before. So I kind of did that first. And from that on, I was called by a couple of journalists about the Snowden case and was asked if there's anything you can do actually under European Union law against mass surveillance. And that kind of started the now kind of famous Safe Harbor case. Just a minute on the facts. Basically, what was interesting is on most surveillance cases, we just have conspiracy theories. We don't really know what they do. And in this case, because of Snowden, we actually knew that there are certain companies that participate in it. We had them like all over these slides. You even have dates where you know, okay, Facebook was hooked up to the system at this and that date. So it was very precise compared to the general mass surveillance debate that we had. What was interesting to me were the reactions in the European Union, or in general in Europe, is we had like demonstrations where people kind of complained about it, and we had the European Parliament making resolutions, and we had the European Commission issuing statements, and we had Angela Merkel getting all upset about her phone, and we had like all this kind of, bullshit going on. Everybody knew this is not going to go anywhere. And I was thinking, after the journalist called me, is there any legal way to really kind of push something in that direction? So what we did is basically, the legal argument in the case was really interesting because it was very, very simple. If I'm that Austrian Facebook user, I have a contract with Facebook Ireland. Side note, a lot of things in Europe, we oftentimes debate it's all these US companies. Actually, if you look at the law, most of them are mainly European companies. For example, Facebook has 82% of its worldwide users, so anybody in China, South America, I don't know where, all operated out of Ireland. Only 18% of their users are operated out of California. It's only people in Canada and the US. So most of these companies are actually like European companies. So if my data, I have a contract with the Irish company, my data then goes to Facebook US where it's actually processed. And the interesting thing is that under European law, you can only send data to another country if they provide what we call adequate protection. And my basic argument in that whole case was, there is PRISM, there is mass surveillance. Mass surveillance is probably not what they meant by adequate protection. Very simple claim, and that was basically the story of how that thing came up. What was interesting from a strategic approach is we really looked at the fact that we now have the NSA in this case and what they call electronic communication service providers in the US, that's this shorthand. So we basically have public-private surveillance situations where the private companies scoop up the whole data and, as we pretty much heard from Wolfie and others before, and then we have the public side basically pulling the data out of this. Second thing, what is kind of interesting is that these companies are now subject to different laws. Like under US law, they have to do mass surveillance. Under European law, that's prohibited. So they're kind of in between these two chairs. The next thing that's kind of interesting is that EU law regulates these third country transfers, so we could actually have a hook to do something about it. And what's interesting in Europe as well is that EU law has to be interpreted in the light of, that's the Charter of Fundamental Rights, so kind of the Bill of Rights of the European Union, the fundamental rights that we have in the European Union, and the European Convention of Human Rights, which is a document that goes even further than the European Union. So we can actually have all these daily data transfers that we do interpreted in the light of our fundamental rights, which is very strong compared to the US, where a lot of these things are not possible. And we kind of took all these elements and mixed that together to have a nice little procedure. The procedure started out at this wonderful little office. That's the Irish Data Protection Commissioner. And that's in Port Arlington. It's 5,000 people. It takes you about half an hour to an hour on the train ride to get there. And then you're instead in front of this. This is a supermarket here. And this is then the Irish Data Protection Commissioner. And to be fair, they have a staircase up here, and that's their office. You see that little fan up here. That's where they are. When we started with the procedure, they had 20 people, none of whom was a lawyer, and none of whom was a technician. And they were meant to enforce privacy on Google, Facebook, LinkedIn. Pretty much half of the internet is in Ireland. The other half is in Luxembourg, where you have a similar office. And that's one of the fundamental problems we have in privacy right now in Europe is we do have all these wonderful laws, but this is basically the enforcement we have. To be fair, they now have double the staff. They got a new office because this picture went all over the media internationally. And if you want to get anything done in Ireland, shame them into the ground, and then they feel bad, and then they change stuff. So the ministry in Ireland actually put out the press release talking about the new office being a Victorian, wonderful, pretty office, and it basically, the whole press release said, the DPC is not in a shithole anymore. And so the problem is they're still kind of the same people. The question is, does the new house actually change anything about their enforcement culture? I doubt it, but anyways. What was interesting is when we came up with that case, the Irish DPC actually went on national radio in Ireland and said that actually this mass surveillance is all true. So that's the quote, "I don't think it will come as much of a surprise that in fact US intelligence services do have access from US companies." So he basically acknowledged that this mass surveillance is happening. However, he said that my legal argument that this may not be adequate protection is either frivolous and vexatious. I love the word. I love to be frivolous and vexatious. Or that they only may investigate things, but they don't have to investigate complaints, which is wrong. Like under Irish law, they have to investigate each complaint they get. Or a combination thereof, or indeed any other relevant legal basis, was the reason that they didn't investigate my complaint. And that went on like for months. That's like the final letter I got. I changed that into a Who Wants to Be a Millionaire? So that's kind of the reason, if you go to the Irish DPC, why you're turned down. It's either that Seoul means may, that you're frivolous and vexatious, a combination of A and B, or any other reason. And that's the reality if you come up with complaints in Europe right now. That was the response in Ireland. Basically, they said that the facts are just like they are, but that my argument is frivolous and vexatious, and that safe harbor, actually this agreement that we had, has foreseen mass surveillance, so that the European Union has seen that there's going to be a mass surveillance law in 2008 when it decided over safe harbor in 2000. That was basically the argument by the Irish DPC. They kind of looked into a little glass bowl and saw, oh, in 8 years there's going to be mass surveillance in the US, and we fully agree with it. Luxembourg, where we filed the complaints, were kind of funny too, is they said that there is not enough evidence for the participation of Microsoft and Skype in any of this surveillance. And the argument was that the DPC of Luxembourg is limited to investigate within the territory of Luxembourg. And that's a very small territory. So if anything happens outside of that territory, they can really not do anything about it. I was really sending them emails like, this is all online, you can download it, but if you have, if you can't download the internet, I'm happily downloading it for you and send it via mail or something. But they weren't too impressed. And Germany is still investigating until today. That was Yahoo that was in Germany. So that was the responses we got from different DPAs. So we ran with the Irish one because they didn't dispute the facts, and the hardest thing to do in mass surveillance cases is to talk about facts. So we wanted to talk about law, so we went with the Irish, and the Irish court sent us actually right to the European Court of Justice. And that was rather interesting. The Court of Justice put out a couple of findings. Back to the Court of Justice probably. It was very interesting because at the hearing at the Court of Justice, none of the bigger member states of the European Union showed up. Only the UK showed up as a bigger member state. All the member states like Germany that cried over mass surveillance over and over again were all not in court. And I asked later in Germany, for example, why no one showed up. And they said, yeah, we didn't really want to interfere with the transatlantic partnership. So we whine a lot in the media, but when it really comes to the court, we rather don't go there. And there was actually a pretty good reason for that, because the hearing was on Tuesday. On a Monday, I got text messages from people saying, guess who is just calling us up and who's calling my boss? I was like, who? The US embassy in our country is calling up my boss that we should change our position on all of this. And I was on Tuesday, the actual hearing day, I was in the court, and a guy from the US mission, that's the kind of embassy to the European Union, came up. And I knew that he's from the mission, and he was like asking me if I'm the plaintiff, and I was like, yes, I'm the plaintiff, blah, blah, blah. And so I was like, so are you done calling up everybody? And I was kind of asking him flat in his face, and like within the diplomats, you just don't do that. And so he kind of stared at me, was like, oh my God, he's asking me like this. And I was like, yeah, we have to really kind of push our interests here and stuff. And then he told me that they only figured out about the court hearing on Friday night. So they only had one business day to intervene anymore, even though that whole case was actually on the webpage of the Court of Justice for, I think, 3 weeks or so. So we were lucky because they didn't have the time to intervene anymore, because on Monday everything was signed off and done already. So that was pretty much the reasons why a lot of these countries then don't do too much, is because the US really puts a lot of pressure on them. And I wouldn't have thought about it. I thought that's more kind of this, the US is anywhere kind of conspiracy thing. But in reality, it really turned up that way. That was kind of interesting. So what did the Court of Justice find is, first of all, that safe harbor is invalid, and that was overnight. So this whole trade agreement we had with the US on how mass surveillance is working or how data can be transferred to the US from the European Union was killed overnight. And there are two things that were really interesting that the Court of Justice said. Is, first of all, they said that mass surveillance violates the essence of your fundamental right to privacy in Article 7 of the Charter of Fundamental Rights. And it violated the legal redress, the lack of legal redress, so that there's no court to go to in the US as a European citizen, violated the essence of Article 47, which is basically your right to a fair trial. And for the non-lawyers in the room, I talk a lot about law because I was told there are a lot of lawyers in the room. Basically, for the non-lawyers or the people that are not too involved with EU data, with EU fundamental rights, basically, if you have a fundamental right, you either have no interference with the right, so no interference with your right to privacy, or, and that's typically what you have, is you have to check proportionality, if it's proportionate enough to interfere with your right to privacy, considering the aim you pursue. So for example, data retention, when they kept all the metadata of all the phone calls and so on, they said it's basically disproportionate, but they never said it violates the essence, and that's kind of the worst thing that can happen. That's basically saying that the violation of a right is so heavy and so crazy that no matter what you do, it will always be illegal. So even if you can theoretically save 1 million people by using that data, you could still not do it because it's too much of an interference with your fundamental right. And the interesting thing is that in our case, the Court of Justice has for the first time found that there was a violation of an essence of a fundamental right at all. They haven't found that before, and that was the case on mass surveillance in the US. The couple of other things that they found, most notably, they said that any other country has to find that we transfer data to has to have essentially equivalent data protection. There have to be effective detection and supervision mechanisms, and there has to be legal redress in line with Article 47. So there has to be a court to go to and complain and so on. Now, the really interesting thing is, this is a much higher standard than most member states, most of the European Union member states provide for their own people. And that was incredibly interesting, because the interesting thing is the Court of Justice, or the European Union in general, doesn't have jurisdiction over the national security of member states. So if the UK does crazy stuff, the European Court of Justice can't do anything about it because according to the European Union treaties, they don't have any jurisdiction over national surveillance. However, they do have jurisdiction over the national security of third countries, like the US. So we were in this awkward situation that the Court of Justice could actually talk about mass surveillance, considering a third country, but you couldn't say anything about, let's say, the UK or France or whatever. So that was kind of a really interesting thing that got a lot of people kind of crazy. But it is kind of, it's important to have these judgments in Europe anyways, because whenever we have cases in member states, they will look at that and implement it hopefully in their own country as well. We saw that the first time around there was a court case by the European Court for Human Rights. That's the court in Strasbourg, and applies to any country within Europe basically. So that's including Russia and Turkey and so on. And they do have jurisdiction over national security. So we already saw a spillover there. There was a case on Hungary where they cited our European case in relation to Hungary in this kind of broader European scope. So what we see with these court judgments, even though this was only concerning the US, is that they spill over into other courts, and that it kind of pushes other courts in member states to go the same way. And that was oftentimes the reason I tried to kind of make this case not a US case or EU versus US case, but more a mass surveillance case in general, which obviously in the media doesn't work too well, because it's much more fun to be anti-American than talk about privacy and mass surveillance. What are the alternatives that we have right now? That's really something that may be more interesting for the people that do practical stuff in the room. Right now, the European Commission came up with what they call Privacy Shield. I'm going to talk about that right after the rest. I just saw that slide actually slipped in. So going back to something else first. What most US companies are now trying to do is to do consent. They say we have consent, so everything's fine. Consent is basically always the option for any US companies. Like basically you have a waiver and all your privacy problems are gone. The problem is that, for example, Facebook is right now using a text saying your data is subject to all applicable laws. And that is how you consent that your data is going to the NSA accordingly. The problem is under European Union law, you have to, consent has to be freely given, informed, unambiguous, and specific. So I don't know if there's anything more ambiguous or uninformed than this line. So if you actually want to use consent, you would have to have a box like this saying, I agree that all my personal data is made available to the NSA, FBI, whatever. And since it has to be freely given, you have to have a yes or no option. So that's not going to work. Especially considering that under US law, there are so-called gag orders, so that these companies are not allowed to talk about the fact that they hand on data to the NSA. And that is basically the clash between European Union law. Under our law, they have to inform you about the fact that this data is all going to the NSA. Under US law, they're not allowed to talk about it, so not going to work. There are a couple of exceptions under the law that if you deal with it in practice, I think you can use most of them for the typical data transfers. So if really like an airline has to send data to the US, if a hotel booking has to go there. So there's still exceptions under the law that you can still use. There is interesting thing that a lot of people use now is what they call standard contractual clauses. That's kind of the surveillance system. and the transfer system that they use right now. The problem is Article 4 of the standard contractual clauses do have a paragraph saying that you cannot use them if there's conflicting national law. So what does European Union law do generally? They say you can't send data to any other kind of country unless you can guarantee that there's privacy protection there. So basically we built a bubble around the European Union saying we know we have privacy protection here. If you want to send any data to another country, then basically you have to either have a country that has the same level of protection as we do, like Switzerland, they basically have the same law, or you basically have a contractual system where you have a contract with a company in another country and have data protection law built onto the contract and then expanded to the other country. That only works if this other country doesn't have laws that conflict with it, and that's exactly the problem we have with the standard contractual clauses. That right now a lot of companies are using the standard contractual clauses, but still you will still have these US surveillance laws that would override these contracts. So there's right now not really any possibility to transfer data to the US that would work in that sense. And I think that's currently the problem. I'm just realizing that I was much faster than I thought. So I'm going to talk a little bit about the privacy shield as well. The other thing that was really interesting is after Safe Harbor was killed, the European Union came up with the privacy shield. What happened is that the Court of Justice killed Safe Harbor, the old data sharing agreement, and then there was a deadline by the data protection authorities in Europe and said you have half a year to send data to the US still, and then we're basically going to stop data transfers. And they couldn't agree on anything new. And on the 31st of January, there was basically the last deadline day. And someone from the New York Times reported that there's not going to be any new deal with the US because they couldn't agree on anything. Turned out that on the next day, Jourova, the Justice Commission of the European Union, came up in the European Parliament and said there is a deal. That was, we didn't know at the time, called Privacy Shield. The deal didn't exist. There was a US NGO that actually made an access request at the US government and asked for the actual copy of the text of Privacy Shield, and they were denied 2 weeks later. And the reason why they were denied was the record you seek does not exist. So they were looking for an agreement that officially existed, and the US government was like, no, the record doesn't exist. So a month later, they actually came up with Privacy Shield, and Privacy Shield is basically Safe Harbor again, exact same text, exact same thing, just with a new name. And what we see right now is that Safe Harbor was killed by the Court of Justice. There was a lot of pressure by the US government that has to be some new kind of deal. And they took exactly the same old text, added 2 or 3 things to it, and called it Privacy Shield and issued it again. So right now we see like a ping pong between the Court of Justice and the European Commission. They kind of overturn Safe Harbor. Commission comes up with the same text, issues it again. It's now called Privacy Shield, going to be overturned again, and we see kind of this ping pong going on. The interesting thing about that was that there was so much pressure from the industry to come up with any deal that they basically rather had a deal like this that is going to be killed than come up with any kind of reasonable privacy protection. And that is actually something where I thought that the European Commission would have had the power to really push it and use that judgment to go further and take the whole data transfer between the European Union and the US as an asset and basically say, if you want to be on our market and if you want to be the cloud provider, the internet provider of the whole world, you got to give us reasonable and good protection at the same time. And that is something that apparently they didn't do and just came up with Privacy Shield and allowed the US to do whatever they wanted to do. So that was something that I was highly disappointed. I was hoping mainly for the judgment that we'll have a lot of economic pressure on the US to give us reasonable privacy protection in Europe by really more or less blocking their market access and say, if you want to provide services to us, then give us decent privacy. Otherwise, you will have a hard time for your companies to be on our market. That would have been a way to push forward probably. I guess we're not going to see that now. We'll see that probably in 2 or 3 years when there is the new, when Privacy Shield is going to be killed by the Court of Justice, because that's obviously what's going to happen. And after that, we'll probably get to that point where we can get something. Thank you. Okay, thank you. We have more time to ask questions now.
Okay, well, I had in big, huge block letters all over this saying, tell Max to speak slowly, because he does tend to get very excited because it is such an exciting topic. Now, you mentioned it. You said, people got sort of crazy about this idea that EU member states also carry out surveillance. And I'm wondering, do you see a hypocrisy there?
In a way, yes. You really have to kind of split it up. In our case, for example, it's Austria in my case, and Ireland. Both of these countries don't really have any kind of mass surveillance. So what happened right now is that the US argues that you kind of pick the worst country in the European Union, let's say the UK, and then the US is basically saying, oh, we're just as good as the UK or just as bad, so we are not like worse than anybody else in the European Union, so everything's fine. It's basically that argument, if someone else goes over the don't cross thing, there's not a red light actually for pedestrian crosswalks in English anyways. So if someone else goes over the red light, then you can do the same thing too. And I think there is obviously the issue that we do have mass surveillance in Europe. That's the reason I tried to kind of push that case to be a mass surveillance case also for European countries. But you can't really make that argument. You can't make the argument that if someone else does something illegal, you're allowed to do it as well. And that's basically what that argument boils down to, I think.
And on how much of the sort of evidence or revelations from Edward Snowden did the Court of Justice rely? Because do we take all that at face value or not?
That is interesting because under the European Union law, it's the member states court that actually determines the facts. So it was the Irish court that we went through that determined the facts on safe harbor or on Snowden's revelations. And they were very strong. Like the court in Ireland basically said there's mass surveillance, it's crazy and so on. I think they went actually a little bit too far. But still what we did in the case is that we tried to stay on very abstract level. So, for example, under the US is, for example, very opaque about what data usage actually means. So they say we target people, we collect data, but that doesn't mean that we use it, even though we target and collect. And so they have a lot of kind of weird definitions of what that actually means. And we didn't really get into that because we made the main argument under European Union law, you're already protected if someone else has to make data available. So we relied on that heavily and said Facebook obviously has to make my data available to the NSA, which already allows me to make my Article 8 rights. I don't really care and I don't have to prove if the NSA is actually looking into my data and doing anything with it. It's good enough that they only have to make the data available. And that is basically what we relied on. So a lot of these factual debates are interesting, I think, to understand, and it's hard to understand. But from a legal perspective, if you pursue the case in the right way, you don't really need it. And I think that helped a lot for our case to kind of really get it to a very abstract level. And EU law is so broad, and European fundamental rights are so broad and so wise in a way, that a lot of these issues are really irrelevant. A huge issue, for example, in the US is standing. So in the US, you can't go to court unless you can actually prove that they use your data in a way, blah, 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 blah. And there's no way anybody can prove that. There is a couple of really Supreme Court cases, and all of these mass surveillance cases in the US were killed by the courts because they said you have to prove that your actual data is used in that filter, which obviously you can't. And otherwise you can't bring a case. And EU law is much nicer, or the general European Union law is that it says only the fact that there is a law that allows interference with your rights is already sufficient that you have standing and can challenge it. So a lot of these things are really nice in Europe to challenge stuff. And that was interesting because there was a lot of kind of backlash from the a lot of push from the US also, because US privacy NGOs then realized that actually in Europe you can bring cases that they tried to bring over and over again in the US and didn't succeed because of the restrictive law there.
Well, I mean, you mentioned Privacy Shield, and I'm quite glad you did because, it's a shield, supposedly, but, it's a paper shield in a way. Partly because of this wording of the US is kind of trying to fudge a difference between what is bulk surveillance and what is mass surveillance, and we don't do mass surveillance, we do bulk surveillance. I mean, is it important to, just lay people to get too stuck up and bogged down in these terms?
That's exactly what we tried to avoid in a way. We really kind of looked at the net law. That's interesting. Again, that's kind of if you really have to look into European fundamental rights to understand it. But for example, our law basically says, or our fundamental rights say, if there is a law that allows something, we assume that it's done. We assume that anything the police can possibly do, it will do. Unless there is a restriction in the law. The US goes the other way around and say, oh, actually, under our law, we can do anything. But trust us, we don't. And that is exactly what European governments have tried over and over to argue, and they were always rejected by our court. So there's standing case law that we can expect the worst, basically, of them. And that helps in these mass surveillance cases, because otherwise you're never going to have a case. And that is a fundamental misunderstanding, if you read the documents between the US and the European Commission, is that they both talk to each other, but both of them talked about totally different worldviews of things. So they talk about the same word oftentimes, but actually mean something totally differently. And that is really interesting, because I think in this whole privacy debate, as I said at the beginning, it's highly cultural. So we oftentimes talk about privacy, but if you go a little bit below the surface, you realize how we talk about totally different things oftentimes. And I think that happened with Privacy Shield a lot too, that the US got frustrated because they're like, oh, we have the same concept, we do the same thing. And then if you look into the details, you're like, no, you're not doing the same thing. This is a different world there.
Well, I mean, Privacy Harbor and, Safe Harbor and Privacy Harbor. That'll be what it's called next, when this is struck down.
We're just going to do a generator for different names for new treaties.
I mean, in effect, both the mechanisms are just workarounds because the US doesn't meet the general adequacy standard in the EU. Now you're going after the clauses. How's that case?
Actually, the Irish DPC goes after the clauses.
Okay.
So the funniest thing
because you're a pain in their ass, right?
The funniest thing happened in this case, actually. The Court of Justice decided that Privacy Shield, Safe Harbor is dead, and it went back to the Irish courts, and the Irish courts told the Irish DPC to finally do their job. So they did their job for 7 months, didn't tell me anything about it, and 7 months later, I got what they call a draft decision. So it's not an actual legal decision, it's a draft decision, so therefore you can't appeal it in courts. and based on that draft decision, they now sue me and Facebook, so it's DPC versus Facebook and Schrems. I'm the defendant.
Ironic.
Over the invalidation of the standard contractual clauses, arguing that I would have said that the standard contractual clauses, which is now what Facebook relies on, that's this other kind of transfer mechanism that is available to them, arguing that I would have said that they are illegal, which I never did. And now we're in the courts in Ireland again. It's going to take a couple of years. And they fully sidetracked the whole procedure again. And didn't do anything about the transfers of Facebook. The fun thing about it, in a way, is actually that if I lose a case like this, I'm the defendant, so I didn't pick that fight. I could end up paying a couple of million euros of the DPC's costs and Facebook's costs, because in Ireland, legal costs and court costs are insane. To give you a perspective, like we had one hearing at the Court of Justice and one day hearing in Ireland for the Safe Harbor case, and my lawyers get around €500,000 for that. If you can now add that we're going to have 3 weeks of a hearing in Ireland in this case, you can kind of calculate how expensive it is. And that's one of the problems we have in Ireland, is that the legal costs and the court costs are so tremendously high that you can't sue another person. And you can't go after the DPC if it doesn't do its job. You simply can't afford it, you go bankrupt over it. And that is something that there's no legal aid in Ireland, there's no restriction on costs. So you simply have the chance to go bankrupt over a case like this. We actually just agreed on Friday that my costs, that they're not going to pursue me for costs. But that was something that was very unclear if that's going to be possible or not. And I still have to pay all my own lawyers now, so I don't really know how I'm going to do that. I'm going to figure that out some way. But that's really the problem, that a lot of these members, like especially Ireland, has extremely restrictive and prohibitive court costs. So that if you fight with Facebook in Ireland, for example, you simply just going to go bankrupt.
Well, I mean, that's part of what I wanted to ask you. I mean, if we don't have redress in practice, I mean, does it really matter whether we've got it on paper? Because obviously not everyone is you, otherwise we'd all be sitting up here on stage talking about this attempt just to defend what is our right. So do you think it's worth having it on paper?
Having it on paper is the first step. I mean, in the US you don't even have it on paper. We do have these fundamental rights on paper. I think the enforcement is really going to be the next challenge. And there is the data protection reform, Gdpr, that is going to come in force in 1.5 years. And the big change, I think, is that the maximum penalty right now is going to go up to 4% of your worldwide turnover, or 20 million euros, whatever is higher. To give you perspective, right now in Austria, the maximum is 25,000 euros. So right now, the lawyers in Austria tell me that if a company calls them up, they basically end up saying, we don't need your services, when they realize it's going to be more expensive to pay a lawyer to be compliant with the law than just breaking the law and pay the fine. And that is the current problem we have in Europe, that this enforcement doesn't work. I do think that GDPR has a lot of possibilities for enforcement. There is the serious penalties. The next thing that is interesting is you will have a right to damages, and also emotional damages, so you just get money for the fact that someone violates your privacy. You have a way to do a class action out of it, so you can have 20 or 30,000 people suing a company because they are emotionally distressed. Then there are options that NGOs and also consumer rights organizations go after you. So then now with the GDPR, really a lot of options to enforce stuff that we didn't have before. To give you an idea, for example, we also did a class action in Austria against Facebook. In Austria, you can already do a class action by other people having their right sign you over. So basically, if this whole room feels...
But that isn't the case throughout Europe.
No, but we used Austria and kind of tried to expand it throughout the European Union. So basically, if, let's say, this whole room feels violated by Facebook, you all can sign over your rights to me. And if you're Facebook, I can sue you. We still have a two-party procedure, but I can basically represent the whole room. That's something that's possible in Austria. And we did that. And actually, we had an app. So we had a Join the Class Action Facebook app. And it was actually for phones, and you had to log in with your Facebook account. So we do make really good use of technology, and very innovative too. And that actually, we did that, and I thought it's going to be a couple thousand people after a year or so. And it was 25,000 people after 6 days. So we had to shut down the whole thing because there are so many people signing up to it. And there was only every third person that really went through the process. So 2 and 3 people gave up in the middle of the process. And you had to take a picture of photo ID. You had to fill out all these forms. It took them 15 minutes on average. And we still had 25,000 people joining in no time. So if you take this experience together with the data protection reform that gives you way more enforcement possibilities, I actually do think that we can enforce the laws that we only have on paper right now in practice as well. And I think that's really going to be interesting and going to change a lot of the privacy landscape in a way.
Well, I wanted to ask you a little bit about industry. And you may have forgotten, but I remember a couple of years ago you said to me, well, maybe in a way I shouldn't have taken the case against Facebook. Maybe that was the wrong company. Maybe it should have been in someone else because Facebook is sort of so in your face. Do you still feel that?
I think Facebook wasn't good from a PR perspective. Because with Facebook, there's typically this argument coming up of, oh, you use it, it's voluntary, you don't really have to use it, and so on. Which is one of the kind of most absurd arguments I think we have in privacy, where you have this responsibility shifting to the user, like the user's fault, he doesn't have any clue about it, but it's his fault that he doesn't have any clue about it. And I think from that perspective, from a PR perspective, Facebook was probably not the best target. However, Facebook is a wonderful target because they're so stupid. They make so many mistakes that you can actually have really nice case lists. So for example, when I asked them once why I got these 1,200 pages, and because typically when you make an access request, you get like 5 pieces of information, and then they tell you everything else we have never heard about, never seen, and proof that we have it. And typically you can't prove it. Facebook sent me all this data with all the deleted information as well. It was 1/4 of it was deleted stuff. And I later asked them why they were so stupid to send me all that data, and the answer was we had internal communications prompts. So someone was just so stupid to kind of burn it all in a CD and send it off to Austria, and I was like, woo, Christmas is here. So that's stuff where Facebook is really probably a good target in that respect, because they, at the time when we started, I think they only had 1 legal person in Ireland that did anything from contract law to employment and whatever, and a little bit of privacy on the side too. So they were just absolutely not prepared for someone knocking on their door and be like, poke, poke, what's wrong here? I think that was probably, from that perspective, was a good target.
Well, okay, I'm checking my Twitter feed, and I feel a bit bad for telling everyone to use this kind of one...
I said that in the break before. It's like we talk about open stuff and so on, and we tell everybody that they have to use Twitter.
Well, it's, I can't see anyone out there, so it's a better way. So I have a question here saying... does anything change in the end between recipient and the company if your cases are successful?
Recipient in what sense?
I'm guessing the recipient of the data, possibly third-party data transfers they're talking about, whereby Facebook or someone will take the information they have and give it on to another
I think the fundamental problem we right now have is this clash of US law with European Union fundamental rights. So no matter what kind of mechanism you put in between, EU law basically says no mass surveillance, and US says mass surveillance. So no matter what kind of thing you put in between here, if it's called privacy shield, safe harbor, standard contractual clauses, binding corporate rules, whatever you want to use, this clash is inherently going to be there. So I don't really think if you have cases where your recipient in the US falls under any kind of these mass surveillance laws, I think that's the relevant point. You are pretty much going to be out of luck. This doesn't apply, however, to all industries. That's exactly what I meant when I said, you know, if you are a hotel booking platform and you send your data to a hotel in the US, this is not falling under any, typically, not 100% guaranteed, but typically not falling under any kind of these mass surveillance laws. So in these cases, you're good, even probably with Privacy Shield or so. However, if you outsource your data to the typical cloud storage or the cloud provider or whatever, they all are falling under these mass surveillance laws. So I don't think there's any way right now as a European company to safely and securely, from a legal perspective, send your data to the US, which is unfortunate. That was my hope that we get something like that. The problem is right now I can only kind of point the finger at the problem. I can't really, the solution is up to politics. And so far I'm not the world leader, so I'm not going to be able to solve that. Probably could run for president in the US, it seems like. Yeah. It seems like anyone can do that. Oh, but I'm not a US, like I'm not born in the US, damn it. They're going to ask for my long-form birth certificate, I guess.
Which I'm sure they already have.
Maybe.
But let me ask you then about data localization, which is, you know, this buzz phrase. I mean, simply sort of put, storing data of European citizens in European data centers, data servers in, you know, in Scandinavia, in Ireland, in Germany. We see a lot of development in that. Do you think that might be a solution, just wall garden, ring fence?
Unfortunately, probably that's the solution right now. It's not really a solution that appeals to me a lot. First of all, I think we need data localization for other reasons anyways, like just the load times and stuff like that you're not going to have if your data is somewhere in California. The big issue is not really where your data is located, but where you have access to the data. So, for example, there is a Microsoft solution in Germany where the thing is that only the German telecom has the keys, and even though it's a Microsoft product, Microsoft doesn't have access to the data. You can have the data wonderfully located in a Amazon cloud or something, let's say in Germany, if there is one, I don't know. But if there's still access from the US, you don't really get out of the reach of the jurisdiction. So you basically have to find a technical solution, which may be encryption, which may be data localization, whatever, that a US company that is relevant here doesn't have access to the data physically. And only in that case you can actually have a very good case, and basically you're legal fully. Anything else right now doesn't really help you much, because let's say you even have data localization in Germany, as I said, it's still a US provider. They may put in the contract that they don't hand over the data, but if there's someone in the US knocking on the door saying this is the court order, you have to, you're out of luck and your contract is basically void then. So I think this is really a level where you need technical solutions basically to be 100% sure. However, that works for your outsourcing if you're like a local company or so. The big problem is stuff like Facebook. I still want to communicate with my Facebook friends in the US. How do you have a worldwide system where everybody can communicate with each other without falling under all of these jurisdictions at the same time? So I think that is something where we don't really have a solution yet.
And we can't all go offline. You're still on Facebook.
Yeah, unfortunately.
Okay, thank you very much. Thank you, Max. And give him a big round of applause, please.